Are you part of a blended family? If so, you better have your estate planning in order. Here's a quick story from a few years ago. I had a gentleman call me on the phone and say that his stepmom had just passed away about 2 weeks ago and he needed to engage our services for probate in order to get the estate through the process and to get his inheritance. So during the conversation, he shared with me that his biological mom died when he was about 6 years old, and his dad married his stepmom, and she was a wonderful woman, treated him as if he was her own son, and everything went well for years. About 10 years ago, his dad passed away, and everything went to his stepmom because everything was jointly owned, jointly titled. She was his beneficiary on life insurance and everything else. So no big deal in his mind because he knew his father wanted to take care of his stepmom and he had no problem with it. Well, now his stepmom passed away and he's trying to probate her estate. So of course, one of my first questions was, did mom or stepmom or dad have any estate planning done? No. And I said, so when dad died, everything went to stepmom? Yes. Then the big question, did stepmom have any premarital children when she married your dad? The answer was yes. And unfortunately, I had to tell this gentleman that he was not the heir of his dad and stepmom's estate. It was her biological daughter from before they got married. So what happens is, at least in the state of Florida, everything that goes to the surviving spouse by operation of law, beneficiary designations, joint titling, goes to the surviving spouse automatically. And when the surviving spouse dies without a plan, it all goes to their closest biological or adopted relative. And so in this case, all of his dad's assets went to his stepmom and then to her daughter. He got left out in the cold. So if this story resonates with you, give us a call and let us show you how proper estate planning for blended families should work. Thank you so much. Have a great day.